Hello, I'm Brenda Wardle, Chief Operations Officer at the Wardle College of Law, which is in Sandton, or Sandton, some say is in Johannesburg, others regard it as a city on its own, but it is situated in the Gauteng province in the Republic of South Africa. I'm a legal analyst and I've analyzed the Oscar Pistorius trial from the beginning for various television networks, some based in the United Kingdom, others in the United States, and also channels, radio stations based locally in South Africa. So why do I think that my 2 cents worth is worth listening to? Well, firstly, I qualified and graduated with an intermediary degree in criminal justice administration. Thereafter, I obtained a Bachelor of Laws degree with 12 modules cum laude. I then completed a Master of Laws degree, and amongst the courses at Masters was Forensic Medicine for Masters, Medical Law for Masters, Advanced Constitutional Law, and Fundamental Rights. Now, the judgment in the matter of Solomon Mkhanyiselwa Ngubane and the state, where the Supreme Court of Appeal, which is, by the way, the highest court of appeal in South Africa, except on the limited grounds where constitutional matters and other matters of interest can be referred to the Constitutional Court, found that the facts disclosed that the appellant, and this was Ngubane, was negligent. And the kind of negligence that the court described in that judgment basically went to say that he intended to be negligent. Now that might sound absurd to legal scholars and legal writers out there. They say he was negligent in causing the death of the deceased, who was his girlfriend, although he relied on the fact that he was in a drunken stupor, if I may put it that way. He stabbed her multiple times, and according to the court record, he can't remember how many times he stabbed her in the region of the clavicle until she died. Now, this judgment looms large in the Pistorius trial. And in the Ngubane matter, the Supreme Court of Appeal altered the conviction on account of murder and replaced that with a conviction on a crime of culpable homicide, decreasing a 10-year sentence to a mere 7 years behind bars. Now, this decision is relied upon to a great extent by the defense in their heads of arguments. And for those of you who are non-legal scholars, the defense is obviously Oscar Pistorius, but his representative, Senior Counsel Barry Rue, and Advocate Kenny Aldridge. Now, in terms of the doctrine of precedent, the Supreme Court of Appeal, all decisions of the Supreme Court of Appeal are binding on all courts in South Africa, all tribunals and fora that fall under the Supreme Court of Appeal. Now, Judge Thokozile Masipa might just have to take this decision into account if she finds that the principles, the legal principles enunciated in that judgment find applicability to the judgment of Oscar Pistorius. So we all know that we moved somewhat shakily from the shock and awe of the tragic events of St. Valentine's Day, 14th February 2013. We went through a dramatic trial with a predictably high degree of theater. Of course, there were theatrics in the court. I put it to you, I put it to you, I put it to you on repeat. There were bare denials by Oscar Pistorius. I didn't do it, my lady. I can't remember what I don't remember, my lady. I shot at the intruder trying to protect Riva and I. But he vacillated between these defenses. We also heard Karras saying that there were black plastic bags used as tourniquets. Now, it surprised me that Gerinel never went into asking why in a house that had a cupboard set aside for towels and linen would they want to use black plastic bags as tourniquets. We heard that Oscar, when distressed, screams like a woman. Reminds us of the Nina Simone song. He screams like a woman. And Barry Roo had said to the Stips, we put it to you that evidence will be led, but in their heads of argument, 360-degree about turn, and they now argue that it wasn't necessary after the evidence of the Stips to introduce evidence to show that Oscar Pistorius, when distressed, screams like a woman. The scene was set by Judge President Mlambo when he allowed the television cameras to zoom in on the trial of Oscar Leonard Carl Pistorius, a household name all over the world, the Blade Runner, the Paralympian. And for the first time ever, the entire world was allowed a peek into our courts to learn firsthand for themselves just how justice unfolds in South Africa. Now, the whole world is sitting on a knife's edge awaiting the verdict of possibly one of the most important cases ever to be tried on South African soil. Legal analysts and experts, perhaps even journalists, are treading somewhat cautiously as none want to be found to have been in the wrong. There is clouded excitement as the trial draws to a close, and everyone is trying to imagine just what the verdict will be come Thursday, 11th September 2014. We sat through grueling testimony. Our bottoms were perched on solid wooden benches for 40 days plus another few days. We took in each nuance. We wondered, we suspected, we weighed, we tried to make up our own minds about the demeanor. We watched Oscar Pistorius retching into buckets when images of a destroyed body of Riva Steenkamp made it onto the screen. And that was during evidence in chief. Immediately, his legal representatives were cross-examining on the same grueling photographs. Oscar Pistorius would sit up straight with his glasses, not a wretch in sight. You're going to judge for yourself. Now, the certitude of proof for criminal matters in South Africa is beyond reasonable doubt. And beyond reasonable doubt doesn't mean beyond all doubt or beyond a shadow of a doubt. And the state's case, National Prosecuting Authority in this case, led by the bull terrier himself, Advocate Gerinel. He bears the onus, or he bore the onus, it's too late now, to convince the court that Oscar Pistorius was guilty beyond reasonable doubt. On the other hand, Oscar was under no obligation to assist the state, as the one who doesn't carry an onus carries the presumption. And the presumption says you need not even testify. You have a right to remain silent. So Oscar was under no obligation to convince the court of the truth or veracity of any of the explanations he gave. In instances where his explanations are found to be improbable, the court would still not be entitled to convict unless it is satisfied that the explanations are over and above being improbable, beyond reasonable doubt, patently false. Now, there are one or two things that Oscar said which I felt, near but that doesn't sound like the truth. But I'm not the one judging the case, fortunately. Judge Masipa has to attach weight to each and every piece of evidence that was led in that court. She needs to say, as the court of first instance, she was there, she watched him, and she needs to say whether Oscar Pistorius's version, or in fact many, many versions, make any sense. The court will be guided by a number of important sources of law. It must evaluate the evidence in toto or in total, not in piecemeal fashion. And to borrow from Gerinel, it is the entire mosaic which must be objectively viewed. It must assess the credibility of all witnesses, including the accused himself, and decide on the weight to be apportioned to each piece of evidence. The Constitution of South Africa is the supreme law of the land, and therefore the rights of Oscar Pistorius, the obligations that are placed on the National Prosecuting Authority, all those are in the end going to guide the decision to be reached, which I suspect has been reached by the court. And as I said, that is Judge Thokozile Masipa, assisted in some instances during that period, important decision-making period, by the two learned assessors. And it's the precedents from the Supreme Court of Appeal and the Constitutional Court which are binding on that court, which in the end are going to tell us what is going to happen. Now, in law, we know that for every counter-argument, there is a valid argument, or for every argument, there is a valid counter-argument. So the heads of argument of the two respective parties will play a very, very important role, because our criminal justice system is adversarial in nature, meaning that they fight it out on the boxing ring, and all Judge Masipa has to do is to sit as a referee and watch and see whether or not the rules of evidence, the rules of criminal procedure are actually being adhered to. She has no other business, so she just has to sit there, listen carefully, and allow the parties to spar as they did. Now, the problem with this case is that it is largely based on circumstantial evidence. We all know that Riva Steenkamp and Oscar Pistorius are the only two people who know what happened in that house on that evening. Now, I lay on the bed in one of the bedrooms in the home of my parents, with a bathroom that is 5 meters away. And I thought, it is so unlikely, given that short space, that Riva Steenkamp, throughout this entire horrid saga, would not have uttered a word. One witness, and this witness has to be approached cautiously, heard an argument about an hour before the gunshots. Other witnesses heard a female screaming. Other witnesses heard a female screaming intermingled with a man screaming. Now, Oscar Pistorius has never ever advanced that he can simultaneously scream like a man and cry like a woman, intermingled. Never ever. Now, the explanations by Pistorius and his vacillation between putative self-defense, private defense, non-pathological criminal incapacity, pathological criminal incapacity where they sent him for mental evaluation, etc., does not really help. So Oscar comes across as someone who doesn't really know what it is that he wants to tell the court. Now, to Oscar's advantage,